Okay, good evening, everybody. This is Jonathan Ginsberg. I think my lead-in was not working correctly, so if you didn't see the normal 60 seconds, that's why. It is July 29th, 2026, our last Wednesday in July. Hard to believe July is almost over, but it is. I have a guest tonight, Noel Anschutz. Noel is a non-attorney rep who's done hundreds and hundreds of hearings, and we're going to be talking about not just hearing issues, but we're going to be talking about artificial intelligence, because that is kind of where everything is sort of headed at this point. I'm using it. Noelle's kind of at the forefront of how it works, and we're going to learn a lot, hopefully, from listening to her and learning about her experiences, as well as how AI can work. Noelle, welcome. Thanks for coming.
Thank you, Jonathan, for having me. I'm so pleased that you invited me, really.
Absolutely, absolutely. I'm going to get, before I start any further, I have a, I don't know, for some reason my Instagram is not working, so I'm going to remove it and we're going to start over again, just so I can get this on here. Let's try this again. Technical. This is what happens when everything is as technical as it is. Okay, so this should now work. Let's see what happens. Okay, let's start really by talking about hearings. So we have a lot of people who are going to be here tonight. They're going to have very specific questions about hearings, how to win, things like that. I always like to start by talking about mistakes. You've tried, and let's first talk about that. You've tried a lot of cases over the years. What do you figure, 1,000 cases you've done?
Oh, 10,000 hearings or more.
10,000 hearings. You
Yeah.
must have started when you're 15, because you don't look like you've done 10,000 hearings.
Thank you.
But that's a lot of hearings, and I think that these hearings, obviously, it's changed a lot. I mean, I've been doing this for 35 years, and when I started, you would do hearings. You would physically have a file, these big yellow folders, 6-part folders that might be 3 inches thick, and to review them, you had to go down to the hearing office and check them out, that sort of thing. So, it's obviously changed a lot, but some of the core principles have not. And specifically, mistakes to avoid, things that work. Let's start, because people always want mistakes to avoid. In your experience, what are the biggest mistakes that people have that they make in the hearing or preparing for a hearing that can really damage their case?
Well, it's a balance between talking enough and not talking too much, first of all.
Okay. And, when you say that, it kind of reminds me that my feeling is that in general, this is my take, hearings, most of whether you win or lose is going to be the medical evidence. You can talk yourself out of a victory by bad testimony. And one of the things I always talk about is, I think when people have what I would call an attitude of entitlement, they walk in there with the idea, I know I'm disabled. Judge, you need to award benefits to me because I can't work and I've basically given up. Would you not agree that is a real problem when somebody goes in with the idea that they are deserving and they just want the judge to validate what they've already decided, as opposed to coming in as, I'm a fighter, I don't want to be here?
Yes, there's a couple of things about that. I don't come across it too much with the clients that I have, but it's something that just vibrates off of the person and they can just tell. So there has to be some adjustment by the representative to ease that person into, well, these are actually the rules. I think people don't have enough education about what the rules are and where they need to focus their testimony. And I think that maybe part of it is a result of that.
When you say the rules, let's unpack that a little bit. What are the things that somebody should keep in mind? They're getting ready for a hearing. What are the things they should have in their mind when they virtually walk into that hearing room?
Mm-hmm. I think people need to remember that the medical records only tell half of the story and their testimony holds the other half. But depending on how specific the person is, you're either going to give them like a Monet painting that's very, fuzzy, or you're going to paint a very clear picture for them. And that's done through various methods, but being specific about certain things is one way.
Yeah. Well, I know one of the things I always tell my clients is eliminate from your vocabulary, not very much, not very far, not too long. Don't do very much. It depends. Some days this, you've got to kind of pick a day. My advice is, if your days run from 0 to 10, 0 being you can't get out of bed, 10 being, you're feeling pretty good. Pick a day that's a 3 or a 3.5. Not the worst day, not even, maybe a little bit less than the middle, and talk about what you could do on a day 3.5, a day that's a 3.5 on a 10-point scale, and not just on one day. If you had a gun to your head, this is about, what you could do month after month, year after year. So if I said to somebody, how far can you walk? I'm not asking them, if their life depended on how far they could walk. What I'm asking is,
Right.
if you had to, if you're in a job environment with the normal stresses of a job and you've got to be on your feet, how many hours could you be on your feet? And I think if you think about it that way, and you also have to, and I think this kind of goes to what you were saying, you can't overstate, you can't let pride get in the way and overstate your capabilities, because that's really not going to help the judge understand what you can do, what you can't do. You've got to be very realistic. You almost need to be somewhat wistful about it. I wish I could do more, but realistically,
Yeah.
this is where I'm at. Well, don't you think that's kind of the way you have to approach it? Because if you're not specific, you're really going to find yourself, with a judge misunderstanding what you're trying to say. And some judges will use that against you. If you say, that you could walk 30 or 40 minutes, that starts to sound like you could do that in a job situation. So,
Right.
so what do you tell folks preparing for hearing? Do you go through all the different things, sitting, standing, walking, kneeling, all those type of things, or do you kind of approach them more generally? What's your approach on that sort of thing?
So I think the 25 years that I've been doing this, I was trained this way. I have always talked to the client for about an hour and a half as a pre-hearing conference, but I
Right.
actually do a mock hearing and go through the questions and ask them. And I end up with a transcript of, what the testimony looks like. Because part of it is there's a format that the judges really like, and it goes back to being specific. They want a number, a yes, a no, or a number, and like a 2-sentence explanation. Like, they don't want to know about when you stubbed your toe in 1972. It's not relevant. It's not relevant.
That's happened to you too. Oh no, I can't.
Right, because there's a couple of things. I tell people, don't put everything in but the kitchen sink, because psychologically you're diluting your case.
Mm-hmm.
You're distracting the judge from like the top 5 things that actually make you disabled. So you don't have to pile it on, and then being specific in that way. But because I do the pre-hearing conference, because that's not how we normally talk, and people have to get into the rhythm of it, because saying sometimes and it's a habit. So I'm trying to break that habit in the pre-hearing. It's a stress test also. Like, if I can stress test you, you're not going to be as nervous at the hearing.
Correct.
You're not going to get blindsided by things.
Yeah.
Because I go through the issues, and some of them are very tough. Drug use, incarceration, people are in the hospital for suicide. I mean, these are very serious conversations with people.
Right. And they're very personal and can be very embarrassing too.
Yes. Or trauma triggering. People get triggered. Their amygdala gets activated because they're talking about stuff that they haven't maybe even talked to their therapist about, I've learned sometimes.
Right.
Mm-hmm.
I had a case just a couple of weeks ago with a woman, unfortunately, who's got very bad irritable bowel. And so here she is, I'm a male, the judge was a male, I think the vocational witness was a male, and she's talking about, going to the bathroom and how often she goes, because it smelled bad, that she couldn't work in her office. These are just things that, you would never talk about with probably your closest friend. I mean, this is just really, really embarrassing, but I had to get it out because I needed the judge to understand, that this is a real problem. And it wasn't just the physical part of it, it's just the psychological part of it. If you're in an office environment and unfortunately, you're in the bathroom and it smells really bad, that's going to impact your performance and impact your reliability and your desire to even come into the office. Things like that. So yeah, so
The
stuff like
funny
that.
thing about that is that testimonies will like a smoking gun because it creates a off-task limitation because
Yep.
you're away from the workstation so much. So like the most embarrassing thing is actually the one thing that might get you disability.
Yeah, absolutely. And again, you've got to be, and something like that, when I'm talking about somebody with irritable bowel, I'm going to ask them, how often do you have to go? How long are you in the bathroom? And, do you ever have to take a change of clothes? Do you ever have to clean up? Because that's going to, again, add up to the amount of time you're off task. And, we use the term off task because in disability hearings, judges, when they pose questions to the vocational witness, they will say, if we have a person who's a hypothetical person who's off task for 15% of the day or 10% of the day. But I've never understood, by the way, some vocational witnesses say 10%, some say 15%. It doesn't make any
Right.
sense why that's not standard, but set that aside for another day. But, if the judge concludes that you're off task 15% of the day, or you're likely to miss 2 or more days, or sometimes 1 day of work a month, that's a real problem in terms of reliability, in terms of maintaining employment. And so
Right.
that's what we want the judge to see. And so again, if a person is in the bathroom, for 15 minutes, every 90 minutes, you add that amount of time up, it starts to become a real problem in terms of off-task behavior. So no question about
And that's why we need the numbers, because the vocational expert doesn't understand. If we ask them, sometimes they're going to be absent. The
Right.
vocational expert's going to look at us like we're nuts.
Right.
So the client's testimony has to support the hypothetical also that's being given. This is the whole goal. That's what I try to explain to people, and that's why I insist on being that specific. The other thing I tell them is think about telling the truth. You take an oath to tell the truth, but it's not about telling the truth versus lying. It's about telling the most accurate truth. Sometimes is less accurate than 2 times a week. 2 times a week is more accurate. That's more truthful. So that's what I try to get into people's head. The more specific you are, the more truthful your testimony is. And people can't generally, and it lends itself to credibility because people generally cannot make these things up. So the more specific you are, the more credibility you're going to earn with the judge.
Right. And I think it's okay, obviously the judge will expect, if you have an advocate on your side, that you will prepared for this. One of the things that used to drive me crazy was I'd ask a question. I never really thought about that. Well, no, you have, that's not, judges want you to have thought about it. You're expected to know, how many times you're going to the bathroom in a day, or how many times you're having to lie down to rest because of severe back pain. You want to be able to give an answer. But on the other hand, you don't want to make your answer, ridiculous. I mean, I give this example last week. I had a client, the judge says, how much can you lift? And the client said, about no more than 1 pound. Well, that just made no sense. I mean, 1 pound is not very much weight. Yet this guy kept saying the judge kept saying to him, I'm going to ask you again, how much can you lift? But he must have asked him 4 times. And finally, my client picked up on it. And, well, maybe 3 or 4 pounds. But by then the damage was done. His credibility was shot. So again, you really want to practice this. And like Noel said, you have a pre-hearing call, practice testimony, however you want to do it. But that's what a good advocate, a good attorney is going to do, is to really help you frame your testimony in such a way that it will match what the judge is looking for, and that is specific limitations that can be put into a hypothetical question, which, by the way, you've heard the term, people have heard the term residual functional capacity. The hypothetical questions are essentially a judge's sampling of various, residual functional capacity assessments. Some of them will be minimal in terms of the limitations, other will be significant, but one of those will find their way into the hearing decision rather. So that's what you're trying to do, is to show the judge that your capacity is so limited by your diagnosed medical problems that you simply would not be reliable at work. And I'll just say one more thing. And again, I think everybody who does this understands it. This is about work capacity. You do not win a disability case in a diagnosis, right? You have to talk about how that diagnosis impacts you in a work environment. And if you remember nothing else from our conversation tonight, this is about work capacity. That is the main reason we are here, because you may have 3 herniated discs and congestive heart failure and diabetes and kidney failure, but if you can still work, you're not disabled. So this is about how it prevents you from working, right? So, okay. What are the things that—
Can I say one more thing about that? It's also about what you can do, not what you cannot do. It's about your maximum functional capacity, but not to the extreme.
Oh, looks like I lost Noel. Okay, I'm sure she'll be back. Looks like we had a little bit of a technical glitch. She'll pop back in. I'll see it when she does. So what she was basically getting at, I think, was when you talk about what you can do, it is very much about you want to talk to some degree about what you're not able to do, but can you lift? How much can you lift? How long can you sit? Things like that. And I think it's important to show that you have some capacity. No judge is expecting you to be completely helpless and sitting in a room by yourself looking at the 4 walls. That is not what this is about. This is about you have capacity, you can function. Excuse me, pardon me. You can go grocery shopping. You can drive the car to the grocery store, to the pharmacy. You can take your kids to school. No one is expecting that you can't do anything at all. But the question is, how limited are you? How limited are you? And what's the maximum you could do? Oh, looks like you're back. Okay, there you go. You're back. You just have disappeared for a second for me.
Hello.
Okay, are you there? There
I think somehow we got cut off.
You got cut off. Okay. Yeah, you disappeared.
Maybe we're waiting for him to come back as well. Hi. So we just kept talking.
Okay.
All right. So we got cut off somehow.
We were just talking about not just what you can't do, but what you can do.
I can't see anybody though.
Okay. Well, I can hear you.
Technical difficulties.
We can see you. We can hear you.
Please stand by. So Jonathan, I don't see you.
You don't see me? Okay. Well,
so we're talking about hearing tips though.
Yep. I had to go on my phone. Oh, there you are. Yeah.
Okay.
Technical difficulties.
We disappeared. This is—
I don't know if you can hear me though.
AI and all the technology, and this is what happens when you rely on technology, right? Are you able to hear me now?
Hang on, I'm trying to get you.
Okay.
Sorry. There we go. I'm just going to put you on speakerphone, and now I'm on my phone with the computer. Anyway, here we go. We're back.
We're back. Okay. So we're talking about not just what you can't do. And I think what I was just saying after you cut out was you're talking about what you can do in terms of how much you can lift, how long you can stand. And my point being, and I suspect you're probably going to get here, is that you don't have to prove that you're an invalid, that you're basically unable to do anything at all.
No.
You can still drive a car and go to the grocery store, things like that.
Right.
So, you're painting a picture, and that's what I like to tell my clients. You're painting a picture. This is what my life is like given these limitations. So that was, I guess, kind of the main points there. Let's talk we'll get to the questions in a second. What are the things that make a good case when you're talking to people? What do you see? What jumps out at you right away? Somebody's talking to you. What tells you this is a good winning case?
Well, that they're going to the doctor is the first thing. So we have medical evidence.
Yep.
And then move from there. But for instance, someone's claiming back pain, but they don't have an MRI. They are not on pain medication. They're not. Social Security expects you to make an effort to get better. You can't just say, I'm not going to do anything so I can maintain disabilities. In some people's minds, this maybe happens. Not the majority of people probably, but some, you have to, they want to see that you're doing everything possible to get better. And then they're going to assess your case, kind of like workers' comp, but there's no percentage rating, I think, maximum medical improvement or whatever term they use.
Right.
So akin to that, but So you need to be pursuing care, and not just a primary care. If you have back pain, go get assessed by someone. You know, we don't want people to be on addictive pain medication, but ibuprofen 800 is not going to cut it, right? And the younger you are, the more evidence you need. You have a
Yep.
heavier burden of proof. You have to prove more. I can get
Correct.
away with less with someone who's older, and et cetera, right? So depends on the case. So you need to pursue care. If you have an MRI, go get an MRI, because guess what? They're not going to pay you until you get an MRI. You're going to
Yep.
cut your money if you're not motivated by anything else.
Well, I
You
think
know.
that this just goes to, I think in every judge's mind, there is a profile. And so if it's a back
Yeah.
pain case, you know, and somebody's saying, I can't work because of a severe back pain case, and there's no MRI or no objective evidence of it, you know, judges expect back pain cases to include MRIs that show something and not just a mild bulging disc. So there's got to
Right.
be consistency between the severity of your symptoms and what the objective evidence shows. And a second point there is objective evidence. Really, really, wouldn't you agree? Objective evidence really important in disability cases.
I had a judge say one time, "Oh, she has back pain. Where's the MRI?" I said, I talked to the client about it, and I said, "She doesn't have an MRI." And the judge's response was, "She doesn't have back pain. Next."
Yeah, yeah,
Moving on, like they
yeah,
cut it, right? It's that cut and dry. There's
yep,
really only in certain cases, maybe you have headaches, they don't expect to find anything on the brain, CT or MR, like you get headache, maybe it's your neck, whatever, that there's some impairments and exception, but generally speaking, you need the objective evidence first, because your subjective complaints, that's secondary. Your
yep,
your testimony is secondary. And I guess in a way that supports what you were saying before, like your testimony doesn't, the medical records are first.
yep. Yeah, and those records need to be consistent. And look, I'm sure you see this too. There are a lot of people that I talk to that I truly believe are disabled. Talking to
Right.
them, listening to their story, but it's about the evidence. And you know, you said this, and this is something I've, you know, you had a judge say it to you, but you know, if there's no treatment, they assume there's nothing wrong with you, and
Right.
it's not fair and it's not right because people don't have the money, they don't have insurance, but you know, this is just the reality of the world. This is that the Social Security world. They just expect that. So, all right. So let's jump into some of the questions. We'll answer some of these. All right.
I'm
So,
gonna
go ahead.
I need to step away for 1 second because
Sure.
I need to get a stand. I had to switch to my phone, but my phone's okay.
Okay. Very good.
I'll be right back.
Yeah, absolutely. Okay. I'll just go ahead and answer a couple of these.
Yep.
Just wanted to say thanks for all you do. I heard that they're going to cut the subsidies for Medicare Part D prescription drugs in 2027, which I qualify for. I had read something about that myself. I do not know. I'm not a Medicare expert, so I don't want to be giving you incorrect information, but I have heard that there will be a change to the subsidies of Medicare Part D as well. So what that means, I don't know in terms of dollars and cents. I don't know if this is absolute, but I have heard something like that. So again, I'm not the Medicare expert, you know, but I think I would definitely keep your eye on that and, you know, research that, see what keeps coming back and what that really means. You know, one of the things I've noticed about the Trump administration is they will float ideas. They floated an idea of changing the grid rules. They floated ideas about various types of things, you know, when Doge was going on, and then they back off. So until it's a done deal, don't assume it's absolute, but I've heard something like that about Medicare Part D. I just am not the person to ask about it. So I'll have to leave it at that, unfortunately.
And
All
I
right.
had a thought about that when they were
Yeah.
trying to do that. And I thought, oh, that's going to require them to revamp the whole DOT situation for them to really effectuate that. And
Yep.
I know they had some panel or something 10, 20 years ago to look
Yep.
at it.
Yep.
And I think it's just so enormous. They go, oh, never mind. We're just going to keep
Yep.
using the
And
DOT.
and for those who don't know what we're talking about, Social Security uses a resource called the Dictionary of Occupational Titles, or DOT, which is a resource that was last updated, I think, in like the 1980s, and some of it was 1970s. And it lists every job that exists in the economy. And in theory, I mean, obviously there's some that probably doesn't have, but, let's say that there's a job, laundry worker, and it'll have a code number, like 123-456-014. And that is a light semi-skilled job. And so when vocational witnesses testify, they will identify the DOT code for the job. The problem is the DOT is terribly outdated. There are jobs, and the Social Security is recognized, no longer exist. And many jobs exist in a very different form than they did when the DOT was written, because a lot of these jobs were set in the DOT when there was very little computerization. There was no scanning. There was there's very, very little in terms of what people, the way they do their jobs now. No cell phones, for example. So the DOT is outdated. Long story short is Social Security has tried to replace the DOT many times and spent millions of taxpayer dollars to do it, and they've not come up with anything better. And so now what we've got is kind of a make-do, where there was a Social Security ruling where basically the courts essentially have said, you cannot rely just on the DOT because it's outdated. We're going to require judges to ask vocational witnesses about their sources. And they can include the DOT, but they have to include other sources as well. And there are things you'll hear, selected characteristics of occupation, or OccuBrowser, or Job Browser Pro, these different programs. And honestly, in my opinion, we don't really know how many jobs exist for a particular job. How many, if you said to me, how many Social Security disability lawyers are there? I don't know. Okay. Nobody really knows. Noel's back here. We're just talking about the DOT and how flawed it is. And that I was just saying that they tried to update it many times. It's not really gone anywhere. The point is that nobody really knows how many jobs exist for any particular occupation. How many plumbers are there out there? How many, laundry workers are out there? Nobody really knows. And the problem is it's very much of a make-do, where you have the DOT as the code, then you have all these other resources that sort of break up. You may have one DOT code and 10 SOC codes for it. And they don't really know how many jobs exist. Social Security it's just basically they made up a rationale that they're accepting. But we're basically stuck with it, because in theory they're supposed to be able to prove that jobs exist in significant numbers in the economy for any particular job the vocational witness comes up with. Again, the problem is that we don't know how many jobs there are. Our point was simply with the DOT is it's outdated. It's not a great resource, but it's basically all we really have at this point. So that's what we're dealing with. It's just one of the fictions that Social Security deals with, and that we have to use this kind of outdated type of thing. Okay. So did you have any? You were saying something about the DOT when you got cut off. Anything more you wanted to say? I mean, just other than this outdated, and it's kind of we work with this. Oh, disappeared again. I apologize for the technical connections, but it is what it is. We'll keep going ahead. All right, Haq Assad is one of our regulars. Good evening. How are you doing? And this is a question I want Noel to be here for, because she's an AI advocate expert. I'll give you my take on it. Given the current and potential use of AI, will you be able to take on more cases without incurring traditional financial burdens usually associated with taking more cases, or use AI to vet cases? I do not use AI to vet cases. Okay, here we're going to go again. Okay, Noel, you there? Okay, well, hopefully you'll pop in here. Haq Assad asks about AI and how it's being used in Social Security practice. As far as vetting cases, the way I vet cases is right here. I've done this for a long time. When I look at a case, I have a pretty good sense right away of whether it's viable. I have call screeners in my office, And so what I will typically do if let's say I've got hearings, this week I had 4 hearings, so I'm not spending a lot of time on the phone talking to potential clients. I have 3 very capable call screeners that work on that. So what we do is we'll call up and we'll ask either myself or one of my call screeners about information about the case. What kind of medical treatment you've got? How old are you? What kind of work have you done in the past? And just get a sense of whether there's enough there, we think, to support an approval. So, could that be reduced to AI? Yes, it potentially could be reduced. It could be something that AI could do. So Haq Assad Noel was asking about, given the current potential use of AI, will I be able to take on more cases without incurring judicial burdens associated with it, or AI for vetting cases? I don't use AI for vetting cases. That's basically where I'm at right now. I use just my own knowledge of it. No doubt that there is a way to use AI to vet cases if you give it criteria. Of course, AI has to be trained. It doesn't know anything. So if you say, if you tell your AI tool, okay, these are the criteria I'm looking for, and you weight them, let's say if you say age 50 is a +3 and age 55 is a +10, or wherever it may be, you could do that. I tend to just look at the individual case. I don't get that many coming in that I can't do it that way. I know, like my colleague Michael Liner, I don't know if you know Michael or not. He has this rubric, and he shared it with me one time. And basically, where his case screeners will score a case based on the criteria in the rubric. It's it's a very formal way to do it, but that is one use of AI. What are you seeing? I mean, you're an AI consultant. What are you seeing law firms or advocacy firms? What are they using AI for? How does it make them more efficient? You're on mute. You need to unmute. Still not hearing you here. Let's see. You're not muted on my side, so. Okay, so nope, can't hear you. So we are not. We're having we're talking about AI. We're having a lot of technical problems. We're not able to hear you here. So all right, we'll get back as you go. But what I would say is I'm not using AI for for vetting cases, because I think it's something that's very individual, at least for me. Where I'm using it is looking at medical records, coming up with just ideas. I have I put a lot of information that I've collected over the years into something called a wiki, where I can ask it questions, my staff can ask it questions, things like that. Just saves us a good bit of time, is really what I'm doing for it. But we'll get, when Noel gets back her audio, she'll tell us more about what she's doing here. Okay, so Noel, I still can't hear you. Maybe go out and come back again, because we're not getting you. We're not getting any audio feed here. Let me go ahead and take you off, and then you can come back on. Okay. All right. Lisa says hello from Florida, and Chloe says hello, good evening. We've got Ron from Arlington, Texas. Hope things are going well in Arlington. Patrick O'Malley, good evening to you. Bernardo Pinoro. Didn't you call my office today? I think you did, but okay. Bernardo, do all cases go to a hearing? No, not every case goes to a hearing. There is, in the disability process, there is a very specific procedure. You file an application that is called the initial application for let's see, we got, okay, I'm not sure what that's all about. I'm seeing something showing up on my Instagram that I don't know who Florida Raider fan is said joined. Maybe he's watching. Okay, I don't know. Okay, let's try it again, Noel. Let's see here.
Okay, so sorry about that.
Hey, now we can hear you. Okay. All right, so let's go back to the AI question. We'll get back
Just
to
move to the phone.
Bernardo's question about every case going to a hearing. Let's actually go to that first, since we're talking to him. His question is, does every case go to a hearing?
My apologies.
And my response is that, there's an initial application, which takes 9 months to a year, about 35% of initial
Can I hear
applications
you?
are approved. Then if you're denied at initial, you go to reconsideration. That's the first appeal. Only about
You're frozen on my end.
you're frozen. I can hear you and see you. So I'm not sure if you have a spotty connection here, but we can hear you and see you. But anyway, to answer the question, reconsideration about 15
I
to
should be able to
18%,
hear you. This is so
and then
weird.
at hearing, about 50% of cases that go to a hearing are approved. So there's a decent percentage of cases that don't need to go to a hearing. But a lot of those are
Sure.
people with really, really serious medical problems. These are not cases of people that are, have mild problems. These are listing level cases typically. So not every case is going to go to hearing because they're really, really severe. Then what I'm finding is if I do a brief, and I brief most of my cases, almost every one of them now, and I get it in early and it's compelling, I've had 2 or 3 cases the last month get approved without a hearing based on the brief. So, and I've had a couple more where I go to the hearing lasted about 5 minutes because the judge thought my brief was pretty compelling. So, okay, here we are again. Now, do you hear me and you see me?
I moved to my phone, so sorry about that.
That's okay. Okay, let's go back to this question about AI. And my question to you is, how are law firms, advocate offices using AI to make their practices more efficient? Would you say? Did you hear me? Did you hear my question?
My internet is very unstable. I'm not sure.
Yeah, it is pretty unstable. Okay. Now, my question was how AI is being used in offices that handle Social Security. No, okay. Yeah, maybe we just have unfortunately not a great internet.
Is it not working again?
Now I hear you and I see you. So I was asking about how AI is being used from your.
Sorry, I have Starlink, but for some reason it's very weak today.
Yeah. Okay. Maybe
I'm not sure why.
Yeah.
Yeah. Well, I think it is going towards people, they want on the intake, that's the rubric. I don't know, because I don't know that lawyers are having staff accept the case. I don't know if that's technically correct. There should still be a professional verifying the acceptance of the case, as far as I understand from school. So, but the rubric is helpful. I think what I also see is maybe like a live inquiry when staff is on the phone with a client, they can query AI and give people more accurate answers.
Mm-hmm.
Also, which is helpful, obviously, for clients. The automation of things make things more consistent, which it's better client service. And I think one of the things that I've heard a lot of attorneys say is, I want to use AI so that I free up time to talk to my client.
Yep. Well, going back to one of the things about using AI as a resource, I was saying when you were off, is I created like a wiki, where I've loaded up a bunch of my videos, other information, cases, things like that into this wiki, and literally my staff can go to it. I put it on, password protected on the internet. They can go to it. They can log into it. They have a question. If somebody asks them a question, what is the look back period for past work? There, it's right there. They can get the answers to that from that. And I use that also, when doing briefs and things like that as a back end resource. So that's one way that law firms can help train their staff by giving, they call it the second brain. You hear these crazy terms in AI, but there was a fellow named Karpicki, I can't remember his name, but he came up with this concept of a second brain, where you basically load up your information, everything you know about a topic, into a wiki like Wikipedia, and you can query that wiki and ask questions of it, and staff can do it as well. And so in my case, I've done this for a long time. I have staff that maybe has done it for 3 or 4 or 5 years. There may be things they don't know. They can ask, and of course, you never want staff to give legal advice, but they can certainly say, well, this is what Jonathan has, in his materials he gave to us. that can be very, very useful. But yeah, I think can be a very big time saver. The thing you always have to worry about with AI, and for those of you who've played with ChatGPT and things like that, number one are hallucinations, which is where, AI will give you an answer because it wants to please. It'll make stuff up. I remember one time, and this has been a while ago, but I asked a question about, a particular fact pattern, and it started talking about the 15-year look back for past relevant work. I'm like, excuse me, it's now 5 years. Oh, you're so right. Thank you for bringing that to my attention. Like, don't suck up to me, AI. Give me the right answer the first time, So stuff like that. The second thing is you got to be very careful because, there's a privacy issue. And certainly, people out there using AI like ChatGPT or Claude, if you're going to do that, make sure you're using a paid version of it, and you tell it not to train on your information. If you're using a free version, they will train on it. And again, I don't think that anybody in the Anthropic office really cares about your bad knee, but it is potentially something that could be out there, and you don't want to do that. The best practice is to anonymize information, hypothetically speaking, a person who's 53 years old with whatever, and you can ask it questions that way. That may not be possible if you can have a look at medical records, but you have to make a reasonable effort to try to make it as secure as possible. I mean, look, in my opinion, there is no absolute security. I mean, unless you're doing things on paper, because if the government of North Korea wants to hack into your router, they're going to do it. If the CIA wants to hack into your router, they're going to do it. I think if you make reasonable precaution,
Right.
and it goes for law firms, right? But I think that, generally speaking, it can definitely save a lot of time, make you more efficient, make you more consistent, and give really accurate information. So, it can be, and going to Hawk's question is, would it allow law firms to take on more cases? Theoretically. I mean, AI, and Noel, tell me if you disagree with me, it is a process. It's not a thing. It's not now we have an AI. It is, you have to work it. You got to be talking to it constantly. You got to be challenging it, ask it to challenge you. You keep making it stronger and better. It's not just a destination where you have, you put in, a new computer system that's got more memory, and therefore you can do more things. It doesn't work that way. You've got to keep, working it. So yeah, in theory, I'll give an example. There are AI tools out there that will allow you to process mail a lot faster. We get a ton of mail. A lot of it's just forms, the same forms over and over. It has to be logged into our case management tool, maybe sent out to the client. That could all be automated in theory. Okay. Now, is it worth the cost? I don't know, but that's an example of what AI could do. It's very mechanical, but it could make a law firm more efficient. On the other hand, AI is not going to think for you. And so if you said that, if you installed Claude or ChatGPT or Perplexity and said, draft me a brief, explaining why this ABC person is no longer able to, meets the definition, should be approved for disability, you're not going to get a very good answer because it doesn't have any context. But over time, if you train it, it could. So that's my take on AI. It is very much of a process that you've got to just keep pounding at and keep trying to get it better. Has that been your experience as well when you're working with people?
Yeah, you have to really, it's more complicated than people think because there has to be guardrails. You can't just let it out into the wild. It will do these things like hallucinations. But there's another more, I think, serious issue that's harder to spot, and that's misgrounding, where the case is real, but it doesn't support the proposition. Right. And so I'm trying to actually figure out how to create a system that, I think one of the things about AI, this may be a little technical, but I think it really is a foundational shift people need to make, is that they keep talking about the security of the platform and the governance of the platform. I disagree. I think that in the legal field, it's the proposition that's taken from the evidence, right? You come up with a proposition, and there has to be human governance about whether or not to allow that into the system, because it's going to go downstream and affect everything else. So it's really about covering knowledge.
Yeah, I don't.
Platform.
Explain. Can you give me an example? I don't quite understand. Can you explain what you mean?
Like, okay, in a Social Security, it'll say the claimant need a cane is medically necessary. It'll come to this conclusion or proposition, or proposition, probably not the term we usually use. And okay, well, where does it say that? What supports that? How did you get there? What's the contradicting evidence to that? And then a human has to make a decision about to accept part of it, or it's just, and the weight of what the evidence is too matters, right? So this is the guardrail, but it also creates an audit, because the court's going to want to know, well, how did you get to that conclusion? And that's the problem that we're having in AI right now, is that people don't know how to produce that audit. How did you get there? Yep. So I think that's what they're going to eventually require, but backtracking that, like, you better build that now. It's going to be a little bit of a nightmare to backtrack that.
Yeah. Well, I find, like, for example, when I'm having it, draft up let's say a memo or something, or a summary, it'll say, we'll keep it with the example of a cane, that, Dr. So-and-so indicated that Mrs. Jones needs a cane, is medically required for ambulation. It'll say exhibit 37F page 3. It's really 37F page 1. And it may say the doctor said, Mrs. Jones ought to think about, if Mrs. Jones doesn't improve, soon, she's going to probably need a cane. That's not the same thing as she needs a cane. And so I think what Noel is saying is, just because AI says it, it doesn't make it so. This is like in the old days, back when the internet became, very well, very common. If it was on a website, well, it must be true. Well, no, it's not the case. Or just because it's on TV, or, and of course, I'm sure everybody sees, the Facebook ads. I mean, the advertorials. Just because somebody says this supplement is going to, restore your full head of hair, and it's going to, give you, help you lose 15 pounds, doesn't mean it's true. So again, I think what we have to realize is that AI, depending on what you tell it, is going to maybe make assumptions that are not always correct, because AI is not a human being. It doesn't know that, a doctor's reference that a cane may be necessary is not really the same thing as a cane is medically necessary. And so, a human person has to look through there and say, is that really the case? Yeah.
And when you mark and the guardrail of defining that gate by letting it in, and when you deny it, you don't erase it from the record. It's just not allowed into the record that goes downstream. As far as, so what we hope is by the time the attorney or the rep is generating the brief, you don't have so much of a concern, because that's been gate kept through the process. That staff there's just a very rigid way to do it, right? But then staff needs training to understand all this new terminology, et cetera. So I think for the client, what we're trying to say is that the more consistent we handle your case, the better outcome you are going to get. And the system learns, so it gets better and better and better, but we have to monitor the knowledge that's allowed in.
Yep. Well, no question. And I'll tell you, I've had people, and I don't blame them for it. They'll put their medical record into ChatGPT and give me a summary as to why they should be approved. And I'll see situations like person has bulging disc, and the ChatGPT will say, you meet a listing. Like, no, you don't. I mean, I know you don't meet a, and again, I'm not, it's not a knock on people who are, using ChatGPT.
People are very curious.
But, I know, and after doing lots and lots of hearings, that, 99.9% of the time, bulging discs are not going to be listing level.
No.
We just know that. But ChatGPT doesn't. All it knows is there's a listing for musculoskeletal, listing 1, and therefore the person's got musculoskeletal problems. Let's make a listing argument. Look,
and
you go ahead.
Sorry, because I'll forget. Sorry to interrupt, but the problem is compounding, because the person putting it in doesn't know what they don't know, and ChatGPT also doesn't know what it doesn't know. And they think people will think medical is the only thing. No, they also, so that's the medical part. The legal part is Social Security also factors in your age, your education, and your work history. So if the system doesn't have that, it's not ever going to accurately advise you about your case, but you don't know that. The client, people don't know that that's the other component. And this is the problem. So please, professional, even we have to look at it and verify.
Absolutely. I think that, look, I think, tools like ChatGPT and Claude and Perplexity, Notebook LM or Gemini, these are very powerful tools, and there's nothing wrong with using them. But again, if using the context of a legal matter, whether it's Social Security or veterans or long-term disability or workers' comp, whatever it may be, there's a lot of context that goes along with that. If you don't know the context of it and you don't know what the rules of the road are for that particular legal area, don't assume that your AI tool is going to know all that stuff. It may know some of it, but it's not going to know all of it. And, you just have to be very, very careful. And especially if you're submitting anything to a agency like Social Security or to a court, I think it's very, very dangerous to do that. I see, there's a lot of resources out there for do-it-yourself legal matters, whether it's a divorce or a will. You probably all heard of LegalZoom, things like that. And now, of course, the AI tools will do a lot of that stuff for you. Just got to be very, very careful. I got a call the other day, and I used to do a lot of bankruptcy work. And I don't do bankruptcy anymore because for many reasons, but I'm really busy with Social Security being the main one. But I got a call from an old client of mine, and she's like, well, I have a friend who filed a Chapter 7, not in Georgia where I live and practice. And Social Security is different because it's virtual. You don't have to be in any particular place, but bankruptcy, you need to be admitted to a local bar. And he filed a Chapter 7 and now, wants to dismiss it, and they won't let him dismiss it. Well, the reason for that is that Chapter 7 is a kind of bankruptcy where you cannot voluntarily dismiss it. Why? Probably because the courts or Congress decided that people are using bankruptcy to stop creditor action, then they're dismissing their case and they're abusing the process. So they changed the rules that Chapter 7 bankruptcy you cannot dismiss. Well, the problem is, if you file a pro se on your own Chapter 7 bankruptcy and your mother puts you on that mortgage or put you on the deed for her house, you're half owner of that house. And so the trustee in bankruptcy is going to say, well, okay, here's an asset I can go after. And you're like, wait a minute, I don't want my mom's house to be taken. I want to dismiss my case. Can't do it. That's an example of, you're penny wise and pound foolish. You didn't want to pay for an attorney. I understand it's expensive. Bankruptcy, people in bankruptcy don't have a lot of money. But, I've seen people put their mother's house, father's house into jeopardy because they filed something on their own without legal advice because they didn't know all the crazy rules with it. Social Security is kind of similar. I mean, there's a bunch of rules here. I mean, a simple one, and people get and I know there are people on here who will do things on their own. If you get to a hearing, if you submit something less than 5 business days before the hearing, they won't consider it. Now, is that made very clear in the materials? Not really. You think, well, wouldn't the judge want to know? Yeah, but if it wasn't submitted properly, it's not going to be considered. And what if the records that you submitted were the last year and a half of treatment? That will not be part of the record. Judges have the right to say, not going to consider it. That's just an example of, you got to know the context of it. And I think the other, and just to make one more sort of minor point is, if you have a case, for example, that is not listing level, you have a back problem and it's bulging discs, which can, along with other things, support a finding of disability, and you make a listing argument, you don't look very credible. Like, why would you make a listing argument if it's clearly not a listing? You're basically telling the judge, I don't really know what I'm doing. Not a good look, not a good thing. And this really goes for attorneys and advocates too. If you're starting out in this area and you make an argument that just doesn't make any sense to somebody who's done it for a while, it makes your credibility, bad. So you have to really think about AI is a wonderful tool, but it's a tool. It's not an answer, not a solution. So that's what you got to be careful about.
Mhm.
Okay. All right. So Patrick O'Malley says, I have excellent news. Approved for SSD after being in the reconsideration phase. This goes to somebody's question before. I believe it was Bernardo. Bernard, I'm not sure if it's Bernardo or Bernard, asked, does every case go to a hearing? Patrick O'Malley tells us no. It's an example, and I've had plenty of cases approved at recon. Basically, that Patrick, filed his paperwork, obviously had a strong case. It was approved at reconsideration, avoided the need to go to the hearing, and he's approved. So it does happen. I'm not saying it happens a lot at recon, but it does happen. So good for you, Patrick. Congratulations.
I have some stats on that.
Oh, do you? Okay.
Maybe they're old, but they still apply. So I explained to clients that the first 2 levels, a lot of people go to hearing, right? Maybe it's like 70% or something, but it depends on your age and your work history also. And it has to do with the residual functional capacity, how long you can sit, stand, lift, carry, basically.
Yep.
And at the first 2 levels, the people who are making the decisions did not go to law school, right? They're lay people, and they're bound by some rules that don't apply at that level, I feel like. But I think the stat was, so if you're under the age of 50, you have to prove you can't do anything at all in the economy.
Right.
And at the first 2 levels,
when you say that, means if there's a job you can fog a mirror and you can be there 8 hours a day, you are not disabled. If it's a minimum wage job, you can fog a mirror, you are not disabled. That's what.
Yeah, they don't care how much it pays or if you've ever done it before.
Right.
Right. So yeah, and at the first 2 levels, they only find people can't do anything at all in maybe like 10% of cases. But at a hearing level with a judge finds people have less than sedentary RFC, so it's this can't do anything at all, I think in like 65% of cases. So there's a huge disparity. So yeah. I guess my point to clients is that, if you have a case and you get denied the first 2 times, don't give up. Get to a hearing, because that might be the first time anybody actually gives you a legit decision.
Yep.
At the DDA, they don't get all the records sometimes. They don't talk to you. There's no mechanism to do that. So I would encourage people to follow through with the process, because I'm sure it's been your experience too. A lot of people give up and then they refile, and then they and you don't ever get anywhere.
Right. You never get anywhere. And yeah, and I think the adjudicators, the claim specialists, think of them like insurance claims adjusters. They work really hard. They're overworked, underpaid.
Yeah.
They've got a lot of pressure on them. I don't begrudge them any. I mean, they work really, really hard.
Right.
Many of them want to do a good job. Not all, but I'd say most of them want to do a good job. But they are so they have such pressure on them to turn cases over.
Right.
Like you said, and I see this a lot. They request medical, it doesn't come in. Okay, they make 2 requests, it doesn't come in. They just go ahead and forge ahead and make a decision with
they don't follow up. So that's the other tip. If you're at the initial and the recon, kind of poke your doctors. Did you give Social Security the records? Did you get the record request? If you don't want to retain someone until you get to a hearing level, but that you can help your case with that.
Okay.
Yeah.
All right. Jody Maxwell says, hello and thank you for your help. You're welcome, Jody Maxwell. Approved yesterday, got your back pay on the same day. Wow. They went all the way back to you when you stopped work without you asking. Okay, just wondering, are they supposed to pay give the lawyers pay before me? Typically, you and your lawyer will get paid about the same time. That's been my experience when they release the funds, because lawyers are paid directly by Social Security. Reps get paid directly by Social Security. So when we get paid, typically you're getting paid the same time. But getting approved and getting the pay right away, that's pretty sweet. I mean, normally I'll see the approval and the money will come about a week or 2 later. But it's nice when that happens. So that's good for you. That's awesome. That's great news. Great news. And Jody, thank you very much for the $9.99. I always tell people this goes to my son does my videos. He's my video editor. So this goes to the Jake Ginsberg lunch fund, and he likes to eat. So he'll enjoy it too. He always tells me, he goes, well, you're not spending all that money just on me. Like, no, I'm buying a sandwich too. So you're not going to get the whole thing for free. All right. Baxter Taylor, will a combination of 3,000 milligrams of Keppra, 400 milligrams of Lamictal, 5 milligrams of Valium, hydrocodone daily, how do I add that to my SSDI claim? Well, I'll give you my take is, you have a medication list, so it'll be shown there. I think, you want to be prepared to testify about the side effects of those medications. You could do something called the Form SSA 795, where you put it in writing, or you could testify about it. Or of course, if your representative, your attorney would do a brief and talk about the side effects of the medication. So I think you want to make sure that Social Security is aware of it. Certainly the medication list would be a good way to do it. Any other thoughts?
Yes, yes.
Okay.
I think that is I'm not a doctor, but that's some pretty heavy duty medication in my experience.
Yep.
So yeah, there's maybe a lot. And then is it controlling the symptoms? How much is it controlling it? How many
Yep.
like regimens of medication have you tried? Because what I've had judges do is, I have all these side effects from all these medications. And the judge tries to get out of that by saying, well, have you talked to your doctor about that? Is there anything else they can give you? Is there another way you can take them? Is it so? Because if you hadn't had, then they're going to say, well, you haven't done everything. They may use it as an excuse to negate the symptoms you're having. So have that conversation with your doctor so it's in the record. But I imagine someone taking that level of medication has gone through quite a process. And I would imagine that is the regimen that is controlling things as best as it can. Because
yeah. Well, and I think, but your point is well taken. That is, if you're taking that amount of medication and it's not controlling your symptoms, and you've got terrible side effects from it, that is a very powerful argument as to why you would not be able to function reliably at work. You're taking that much Keppra, that much Lamictal, Valium. How much can you focus and concentrate? What can you remember? What can you do? I mean, if you're basically just a zombie,
fatigue,
all day, you're not going to be very effective at work. And again, you have to take it down to a simple entry-level job. Let's assume, and again, I'm not going to say that a judge would always do this, but I think it's reasonable to assume that a job that's a fairly sophisticated, highly skilled job, one where you're responsible for other people's livelihoods, you're not going to be able to do. Probably not driving with a medication regimen like that. But what about an unskilled job where you're sitting there, you're putting ink pens in a box, you're counting, something coming down an assembly line, making sure that the stitching is right. That's an example of, could you do it even with some side effects, with a certain amount of pain, with a certain amount of, medication side effects that impact concentration, but you hit a threshold where can't do it anymore. And that's what you got to really argue. And that's, again, where in testimony, your representative would bring out in testimony, we talk about that. Maybe have a third party fill out a form or write a statement as to what you're like when you're taking these medications, because that could be evidence as well. Okay, Big Ta, one of my regulars here. Thank you for your expertise. I'm in the middle of two different claims, one in federal appeals and the second is a recent one. Anything I can do differently? That's a tough... I don't see the rest of it here.
Depends on how old he is, like what the vocational profile looks like. Because usually what I find is the cases just get combined at the end on the remand, and then the second case is coming up for hearing. And if you have a case in federal court and it gets to OHO, they're going to hold it until the federal court case decision is made. And then if that's a remand, they're just going to send it back through and consolidate the cases. I have found that unless you have changed an age category, like you turned 50 and you've never done a sit-down job, or you have a new impairment, but to your point, if you don't have enough medical evidence, you gotta, like, that would make a difference, but maybe not in the federal court case because it's really when the evidence starts. So there's all these different factors that probably go into.
I think that, the federal court's going to be looking at an error of analysis by the judge. The judge didn't apply the law correctly, not whether you're disabled or not. So I'll give you an example of one that I got a remand on. The judge found that my client was limited to using handling and fingering was occasional. That was the finding. Her hypothetical said handling and fingering frequent. So there's a disconnect. The judge found it was occasional, hypothetical, frequent. Case denied on the grounds that, based on that hypothetical, she could do frequent handling and fingering. The district court said the judge needs to reconcile this. She's found on one hand it's occasional, but she also gave a hypothetical with frequent. We don't know what the answer to the hypothetical would have been if it was shown as occasional. We don't know. The judge could have still denied the case or come up with a different hypothetical. That's an example. Now, the fact that the district court did that maybe is telling the judge kind of, behind, sort of read between the lines, you need to take another look at this case. But that's an example. It may make no difference whatsoever in the judge's findings. On the other hand, it could be a major problem where the judge failed to consider the person's back problems when there's an MRI showing 3 herniated discs. That could be a major substantive issue. So, it's just a matter of what the reason for the district court remand might be. And as Noel said, age change categories are a big deal. So what that could mean, Big Ty, is, you may get into a second hearing and the judge might say, well, I'll approve of it as of your 50th or your 55th birthday and ask you to change your onset date and do a partially favorable decision or amended onset date decision. And you may have to decide whether you want to go with that or not. So that's a lot of times what happens when you have these sort of long drawn out, appeals and remands and things like that. Okay. Okay. So Patrick O'Malley, who got approved, says, and you're right, and Noel just said this, don't quit. Just keep pushing ahead, because the fact that you're denied an initial recon, in my opinion, means nothing.
Right.
It just means that an adjudicator, didn't have the time or didn't have the information necessary to approve you, but that doesn't mean anything. I mean, every case I try has been denied twice, okay? And I win most of them. So that just
Right.
says that the people that are making the decisions early on didn't have the full picture for whatever reason. So do not give up. I would agree with that. M. Steele from Savannah, Georgia, in my neck of the woods. My dad was born in Savannah, as a matter of fact. Been there many, many times. It's a little humid and warm in Savannah, Georgia, I will say, though. Okay. Can AI, Chloe says, identify weaknesses in a disability case that an experienced representative might overlook? Is it more valuable as a tool for organizing and analyzing evidence? I think both. I mean, I think that, anytime a second pair of eyes looks at a file, there's no harm in that. I mean, certainly if AI looked at something and found something that I missed, doesn't offend me. I'm happy to know that, or somebody else, if my paralegal looks at something and caught something I missed, fine. So I think that, AI can do that. Now, you don't rely as a representative, you don't rely on AI to make your arguments for you. But yeah, if you missed, there was some, reference in the record on, page 37 that the person, was, I don't know, was having seizures or has an allergic reaction to the main medication that, controls symptoms, that could be very, very relevant. And so AI might catch that or not. But yeah, so that's one way AI can be used. But yeah, certainly organizing and analyzing evidence, both.
Yeah.
I mean, I think AI is it's a tool. Look, it is a tool. The way I look at it, Noel, see if you disagree with me or agree. It's like a really smart assistant who works, 24/7, doesn't take any breaks, and will do anything you ask him or her to do. They're really smart, but they don't have any knowledge. And the more they learn, the more you train them, the more effective they're going to be. And yeah, anybody can come up with something that, that you maybe didn't see. So absolutely, I think it's a great tool. Is that the way you look at it? I mean, it's a really smart but untrained tool.
Yes, there's just certain concepts that can be placed into the system, though. It's just asking about, does it look at contradicting evidence? I mean, one of the things that maybe is unique to Social Security is we have to submit everything, even if it's adverse to your case, number one. So in my system that I've developed, it does have a contradicting agent before the human verification that brings out the adverse evidence. So as the professional, we have to actually weigh that and look at it and use our own judgment. That's it. The system is not going to do that. It doesn't replace that. And all of the evidence has to be considered. And it does look at consistency across the board, whether it's bad evidence or good evidence. So the judge is trying to weigh that, but it has to do with like, well, what kind of evidence is it? Physical therapy records and chiropractic records, really, because they're not an MD, if it's not an MD treating you, don't have as much weight as your surgeon, you know? So even medical records carry different weights of that the judge is going to assess it. So that's also a factor. But yes, it does. We should be bringing out the contradictory evidence because we don't want to have confirmation bias.
Right.
And that goes downstream and skews the arguments because then you're not arguing against anything.
Well, I think also if you can be proactive about it, if you
Right.
see there is something in there that's works against you and you address it, that's better than waiting for the judge to, assuming the judge ain't going to find it. The judge will find it.
Oh yeah, they're going to find it. You can't hide it. This is a good example, like with drug use. If you can identify that early on, I've had clients that I said, you cannot use any drugs during this case.
Yeah.
And these were, you know, I think it's trauma. Let me just say that. I have nothing against people who have that issue because that's not really the issue, but they will use it against you in a social security case, you know? So, but I had a client, she did not use the whole time she had the case. I was so proud of her.
Yep. Well, look, I had a situation. It's a case I'm working on, and I asked AI. I happen to use Claude, but I said, you know, ask me questions, challenge me. I'll tell it.
Right.
So, you know, it asked me about, you know, I had a pre-hearing call with my client, and I kind of put, you know, some of the things that were in there because I'm putting together my direct examination, and AI is kind of assisting me with it. And one of the issues was, or one of the things my client talked about was, and it's in the record, and AI flagged it, your client said that he works out, okay? And he's got, you know, some medical conditions that will seem to be inconsistent with that. So I asked him about it. I said, okay, the record says you work out. He goes, oh yeah, he goes, I have a couple of hand weights here at the house, and when I'm feeling up to it, I'll live, you know, for 5 or 10 minutes, I'll take 5-pound weights and do that just to keep muscle tone. That's a lot different than working out, which sounds like you're going to the gym. So, you know, AI,
and this goes back to like frequency and duration. Well, how often are you doing that? Once a month, once a day? Like this makes a huge difference. And this is why it's important to be that specific because the case can turn on these details.
Yeah. Well, AI, the thing is, what AI said to me, what Claude said to me was, make sure that you talk to your client, or I suggest you tell your client, instead of saying I work out, say I have a 5-pound dumbbell at the house that every, you know, once a week, I'll spend 5 to 10 minutes lifting, which is what he told me. And not even lifting, just, you know, just trying to keep a little bit of muscle tone. He says, but you know, if you just say working out, the thing the judge is going to think he's going to be down at LA Fitness,
right,
you know, for 3 hours, you know, lifting hundreds of pounds of weight and swinging kettlebells. That's not what he's doing. So that's an example where AI said, here's something that could be a problem. What is, you know, find out what the story is with this. And here's what I would suggest based on what, you know, you reported back, how your client ought to frame it. And so when we practice pre-hearing, we talked about that. I said, okay, you know, if the judge should ask you about working out, how are you going to answer that? You know, like I said, his answer is, you know, maybe once a week, once every couple of weeks, I'll pull the 5-pound dumbbells out and I'll just, you know, do a little bit of lifting for 5 minutes or so just to keep a little bit of muscle tone, but I'm not bench pressing anything. I'm not swinging kettlebells. I'm not doing anything like that. But that's an example of where AI could be a very, very useful tool. Okay. Okay. So Baxter had again, I think we already talked about that, all the different medications. Lisa from Florida, hearings 2 weeks before your 50th birthday. Is that a good thing? Well, not necessarily, because well, let me answer the 2 ways to the question. When you filed your application for benefits, you alleged an onset date. I'm assuming your onset date, you were 48 or 49, something like that. Okay. If you're approved, it's going to basically be as a younger individual under the age of 50. However, the judge also has the option of treating, there's a rule, I think it's a PALMS regulation that says if you're within a few weeks to a few months of a threshold birthday, they can treat you as if you were 50. So in this case, so theoretically, the judge could say, well, it's your hearing is in August of 2026. I'm prepared to find you disabled as of June 1 of 26, which is essentially close to your 50th birthday. Now, the problem there is no past due benefits if the judge does that.
Mhm.
That is something that could happen, but being close to 50 doesn't really help you, unless you're prepared to give up a lot of stuff, is what I'm going to go to. So I would not, even my opinion would be I'd focused on your disability began when you were 47 or 48, and that's what you're arguing.
I have a little detail on that turning 50, I think. So yeah, it's not a bright line rule. They can, I think it's 6 months before your
Right.
50th birthday, but I find the judges only apply that when the DLI, the SSDI benefit is at risk. Then
Yep.
they'll push it. Mhm.
Yep. Yeah, that's true. That is pretty common. So if the person's insurance is going to run out, they could apply it a little bit earlier. Although I've had judges, use a non-mechanical application of the grid and approve somebody at 49 years and 10 months or something like that. But
Oh, okay, yeah.
But in this particular case, I don't think that Lisa's 50th birthday being 2 weeks before after her hearing is going to really help that much, honestly. I mean,
the judge could, I think judges have held decisions until the person turned 50 and then approve them as of age 50, though, because it'll just come back on remand if you keep, or they'll start all over. We don't want to do that, but yeah.
Yeah.
There's some weird scenarios.
The point is, in all these scenarios, you're looking at probably not getting much in the way of past due benefits.
Right.
And so, you might get ongoing benefits. And if that's what you want, that's fine. You hate to see people lose 2 or 3 years of past due benefits. That could be $30,000, $40,000, $50,000.
A cautionary thing about that is you have to be careful appealing, because you open it up again.
Right. The whole thing.
Remand, they can revisit the whole case and decide you're not disabled at all. So you really have to, if they're gridding you at 50, probably you're not going to lose that. There's other scenarios where that might you have to be, that's a risk assessment that has to be done between you and your professional.
Yeah. Well, and the other thing is, if they remand it back and it goes to a different judge, maybe you had a judge change the onset and approve you, at a certain age, and you want to go for those 2 or 3 years of past due benefits. The judge that approved you approves 49% of cases, kind of right in the middle. That judge moves on. You get a new judge who's a 25% approval rate. That's a real problem. I've never had that happen to me, but that would definitely make me think twice about it. My rule of thumb is if you're looking at going after $10,000 or less of past due benefits, I think real carefully about it. More than that, you got to start thinking about it. $100,000 of past due.
Like, take your money and run.
Yeah.
They say.
Sometimes
Maybe.
it makes sense.
Yeah.
Okay. Hal Clayton says, thank you for your videos and the encouragement. Absolutely, Hal. That's why we do this. And ultimately, this is confusing. It's very stressful. There's a lot of, I always talk about the terms, DLI, OHO, SGA.
The acronyms.
All these acronyms, and nobody knows what these things are. You have somebody who understands it and give you a path. I think that one of the things that a good representative can do is to have kind of a working theory of the case. What is the argument we're making? What is the evidence we're relying upon? How do we get from here to there? And, I'm a big believer that you're not going to be successful in a case if you don't know where you want to end up. You got to know what do you want the judge to do? And do you have the evidence to do that? So, just taking this very step by step, just going through the 5-step sequential evaluation process, making sure you can't do past work and looking at it realistically. I talk to people, if you're 35 years old and you got a bulging disc and not insulin dependent diabetes, you're probably not going to win. I just, to be straight up about that. And I'm going to tell people, I mean, if I talk to somebody, I just don't think there's enough there. You're too young. The impairments are not severe enough. I'd rather tell you that than say waste 2 years of your life waiting for something that's probably not going to happen. I mean, is it impossible? No, but is it likely? No. So, that's what you try to give to folks. All right, Jam G, Patrick, congrats. Yes, currently in recon. Thought about giving up. Don't. And you said I refuse to give them satisfaction. This is not personal. Social Security is this huge bureaucracy. Nobody there is looking at Jam or Patrick and saying, let's really screw this guy over, this person.
Right.
That doesn't happen. But yeah, you are kind of a number, and they look at, the adjudicators are looking at you're one of 500 cases they got to deal with, or 200 in any particular time, whatever it may be. And yeah, they're not thinking about the human component of it, how much suffering you're doing, how much not having any money coming in is affecting you, your family giving you a hard time for not working. They're not thinking about that. They're just looking at the rules. And I don't think that's a factor for a judge either, but you're a human being. And I think sometimes Social Security, because it's this bureaucratic process, they lose track of the fact that, these are people that are, waiting a long time for their day in court. That's why, honestly, it kind of pisses me off, to be frank, when a judge is rude or just dismissive of a claimant. I mean, anybody who applies, in my opinion, they've made a difficult decision to declare themselves disabled without label. That's a tough label to have. And I think judges ought to show respect to anybody who is coming before them. I mean, nobody wants to say, I would say, I've done this a long time. I can count on the fingers of one hand the people that were just trying to game the system. Most are not. And if I pick up on that, they're out. Most people, maybe they overestimate how bad their condition is, or they get a little too invested in being disabled. But for the most part, this is a really tough decision. And I think judges ought to be aware of that, and to, if they're running late, for example, apologize to the, sorry, I'm running a little bit late. That's all you got to say. Most judges will do that, not all. But yeah, I mean, it's a big deal. I mean, this can be life-changing, whether you have that money coming in or not, and that Medicare can really be life-changing. All right, Chloe says, medical records are often hundreds or even thousands of pages. How can AI help identify the evidence that truly matters without missing important context? Great question. What do you think, Noel?
Well, Social Security thankfully organizes the file for us, and it's numbered.
Yep.
So we have that, but the rules dictate what it is pulling out. Like, we're looking for the MRI first, or if you have seizures, did you get an EEG? If you have fibromyalgia, where maybe they shouldn't do the trigger point test anymore, but are you meeting the criteria that they're looking for? And that gets pulled out first. Then we're looking at the consistency. Are you compliant? So yeah, for a very, I think, long time now, AI has been able to create chronologies, but it has to be checked to make sure that it, like you had mentioned earlier, it's on 13F1, not 13F3. It might be like a little off, but as we use it, it gets more and more accurate. And it depends on how, the tech on the back end is working also, whether it's making that easier or harder for the person using it. But yes, that's entirely possible. So instead of looking at 3,000 pages of records, we're reading a chronology, and it's much easier in our head to keep track of, and we can see the timeline also. If you have to amend an onset date based on something, you can easily pick that out. And it's helpful for the judges also. I give the judges the chronology. I think the decision writer's happy.
Yeah. Well, I will say this about chronologies, and there are a lot of vendors out there who will offer services for chronology, and I've used several of them. The problem that I've run into, and I haven't done it in a while because now I'm using Claude to do it myself, but I'll get a 50 or 60 page chronology. Well, that doesn't help me.
Yes. I've had that happen too. I'm like, is this as much work?
Yeah. I mean, when I did it manually, and I'll still do it manually sometimes, or at least partial. I mean, I would get everything down to 3 or 4 pages because I was, I knew what I was looking for. I'm looking for that EMG. I'm looking for that MRI. I'm looking for the doctor's visits that talked about, no surgical remedy available. Refer to long-term pain management. There's certain really key exhibits in almost every file that just tell, there's certain exhibits in a file that have a nice history. I mean, I love it when there'll be a good doctor who will go through like 3 or 4 years of history all in one page. Great. That gives me a great chronology there. So, the automated chronologies a lot of times are just too long. So what I'll do is I'll just say, okay, find me all the MRIs, find me all the EMGs. Like you said, I've never actually given a chronology to a judge. An interesting idea. I've had AI do it for me, where it will identify all the MRIs, all the objective tests, and I use that when I'm drafting my brief. But yeah, I mean, I think those chronologies can be very, very useful, but they can be too long and they may not know what's important. I remember one time I had a case and I had a chronology company or one of these vendors do it, and my client had gone to a podiatrist. She was having terrible problems with bunions or something like that, but that wasn't her main. She was like, congestive heart failure, but she had bunions. But she had gone to the podiatrist a lot recently. Well, this chronology is focusing all on the podiatrist and her bunions. I'm like, wait a minute, she's got congestive heart failure. That's kind of a lot more important than her bunions. I'm not saying the bunions weren't painful, but that's an example of where an automated service isn't going to be able to make a qualitative decision. So yeah, you got to look at it and figure out what's important. And again, when you're training AI, you train it. Okay, objective evidence is really, really important, much more so than records from a chiropractor, which is not an acceptable medical source. Just stuff like that. And so it can be very helpful, but if it's trained properly and if it's reviewed. And I look at, like, when I'm submitting a brief, if I'm referencing an exhibit, I personally check it, because if you don't do that, then you don't need to have a judge say to you, well, counselor, I'm looking at your brief and you refer to 29F, page 33, and I'm looking at that. There's nothing on that page. You don't want to be in that situation. So you got to check it.
Yeah, and I think that some people might say, well, it's not case law, it's not this, so maybe it doesn't really matter, but it does matter.
Yeah.
Because it's our credibility, and the same standards should be applied across the board.
Yep, I agree.
Yeah.
Big Toss says, I'm going to give you a question. I'm going to give you an umbrella. He's not asking for specific advice. Kind of an overall answer. The ALJ gave me an RFC of sedentary in November. Can't do past work, but I was 49. I turned 50 in, what do you turn 50? Big Todd, I don't know when you turn 50 here. I don't know. Okay. I don't know when, but
whenever you turn 50.
Yeah. Okay.
Yeah.
So, well, first of all, if you already had an ALJ decision, that means you're either an appeal or you're starting over again. So one point is, if you had a decision, an RFC in a prior case, there is some law out there that says that, unless they can distinguish it, they can't give you a less restrictive RFC in a second case. Not absolute, but it's basically, they can't, Social Security finds you limited to sedentary. They can't now find you limited to light unless there's clear evidence that's the case. So this may be a situation where you're filing a new case, then your case may be stronger because you've already been found limited to sedentary and you can't do past relevant work. You might very well meet the grid. That's what I'm thinking there.
Yeah, they also say, like, your cases have substantially worsened.
Right.
Mm-hmm.
Right. I mean, every once in a while you're gonna have a judge. Well, you could do light work, but that's a tough one to go there. Okay.
Mm-hmm.
All right. Okay. Okay. Madeline works with me, saying congratulations, Patrick. Hello, Madeline. Okay, October with a new claim. Okay, so so Big Todd does have a new claim up. Yeah, I think, again, you want to demonstrate that your capacity has not gotten better. If anything, has gotten worse. And again, if you were represented, your attorney should reference the finding in the prior decision that you're limited to sedentary work and you cannot do past work. Again, is it absolutely binding on the judge in the new case? No, but it should be pretty persuasive, I think. Okay. KU Thunder. How are you doing, KU Thunder? Hello to KU, who's here fairly often. Okay. Baxter. All right, Baxter is the one who's taking all the medications. The SSA psychologist in 2023 noted he was borderline intellectual functioning. A 2026 neuropsych evaluation said he's intelligent. They both agree on memory loss and cognitive decline. She was on a bad day, good day example. It's kind of hard to answer that, Baxter, honestly, because, you know, every case is going to turn on the facts there. It is interesting that you would have one psychologist saying you're borderline intellectual functioning, the other saying that you're not. You know, I think this is one where your representative is going to have to sort of choose an argument to make and try to distinguish those two and how they can be reconciled. You know, I don't know. It could be good day, bad day argument that, you know, when you saw the first doctor, you were having a really bad day. You're having a good day when you saw the second, but you're going to need more. I think you're going to need some evidence to back that up. That's my take on that. Yes, ma'am. What say you? Noel, you're muted.
I know, have a busy street, so I'm trying not to. Okay, but anyway, I had an experience with a judge regarding this issue, that IQ, borderline, this is the IQ issue, right? So one of them was that the judge told me, IQ, that number doesn't change in your lifetime. It doesn't fluctuate unless you have like a motor vehicle accident, head trauma, or something like that. So when you get those conflicting reports, that really does a number. And it's very expensive, but you could go to is it like a it's like a forensic psychologist, whoever it is, right, and get an IQ administered independently. It's expensive. I've sometimes tricked, Voc Rehab in some states into doing it as part of the evaluation for the client. So I'm like, go to Voc Rehab because they might do an IQ, they'll send you possibly. So, so that's a tough one. And I also find that even if the person's IQ is low, if they've worked or functionally don't operate at that number, they'll disregard it.
Yeah. Well, there's different ways to challenge it. I mean, I don't know if I would agree that your IQ doesn't change, or it could depend on the testing. It could be depending on the testing environment.
Maybe. Yeah.
A lot of things. I mean, there's a lot of reasons to question what an IQ test really
means.
That
was that judge's position because he was, but yeah.
All right, Chloe says I'm blurred. Chloe, that's what I look like. I look blurred because, when you get to my age, you kind of look blurred. Okay. Patrick says, okay, thanks. Okay, so you tuned in. We talked about the griddles. Yeah, absolutely. That's a great way to do it. What are the most common questions an ALJ asks the claimant? Are there must-ask things? Well, you're always going to be asked about your past work. Okay, so you need to be able to talk about that and look at your work history form so that you're consistent with what you talked about with your past work and how much you lifted and carried and all that kind of stuff. So you should have that pretty clear. And there's a form that you filled out earlier where you go into detail about your past work. You can expect to be asked about, if it's a physical case, things like how long can you stand? How far can you walk? How long can you sit? Can you kneel, crouch, crawl, stoop? Things like that. How much can you lift frequently? How much can you lift occasionally? Do you have to take breaks during the day? Any trouble with household chores or personal care, things like that. They're just certain questions that you kind of get over and over, but it's, most of the questions are going to really be to determine whether you'd be able to function in a work environment. So they're all going to be asking about specifics, I think, is what I would say. I mean, that's a place you could probably go to a chat GPT and say, what are common questions I might get at a Social Security disability hearing? It's probably going to give you most of those because that stuff is out there. That's my take. Noel, what do you think?
I put the questions in my pre-hearing packet that I give people. Yep. But there's like 5 categories. It's the basic information, your work history. And I find judges will say, why can't you work? And oh my gosh, that leaves it open to so many answers, but they want to know.
I call it elevator speech, right? You want to
Right. But
yeah.
it's what are your mental health impairments? What treatment are you getting? What medication are you on? And what symptoms are you having? But like the frequency and the duration of those, how they're affecting your functioning, like grocery shopping, chores, what do you do for entertainment? And then sitting, standing, lifting, carrying. I think maybe that's really all they care about. Like if you can't climb stairs, they're not that concerned about that limitation, generally speaking.
Yeah.
So those are the basic areas.
Yeah. I mean, I think if it's physical and you're under 50, or even if you're over 50, you know, they're looking at it saying, I'm a judge, and his mind is saying, or her mind is saying, okay, here's a job. You're sitting at a table and you consider stand, they call it a sit stand option, and you're putting light items in a box to pack it. You're wrapping things up. They call it a job they used to call foil wrapper. You are monitoring security cameras. That's not one they use anymore, but that's an example of a very simple entry level. They call it SVP 1 or 2 job. That's the easiest job that exists. Basically, you're just there. You have to be a breathing human being. And of course, when you're over 50 and then 55, you have the grid rules make it a little bit easier. But generally speaking, that's what judges are looking at. So they want to know, how long can you sit? How long can you stand? How much can you lift? Because they're going to come up with a functional capacity argument for you. But most cases, honestly, turn on, off task, and miss days from work. Are you reliable and dependable? That's the main thing. But I think that being able to give specific answers to questions about functioning is really, really important. And if it's mental, or if you have chronic pain or on pain medications, are you dizzy? Are you able to, can't focus and concentrate? Short-term and long-term memory, stuff like that. But again, this is where AI could be helpful, giving you a list. Okay, Linco. My son was on SSI for 5 years. After 3 strokes and hemianopsia and grand mal seizures, we got a letter a month ago from SSA saying he's no longer disabled. We appealed. I guess my first question for you would be, was there any new medical that suggested he got better, or did he go to work? Is there any earnings that are showing up his earnings record? Was there any reason they would say he's no longer disabled?
Or did he turn 18?
Yeah, possibly that could be it too.
They love to cut people off then.
Yeah, that could be, yeah. I mean, sometimes they cut people off and there's no really good reason for it. But yeah, I think appealing would be smart.
I think they cut people off when they're 18 because the children's rules are very different from adult disability.
Good point. What Noel's getting at is, if you look at the listings, if you go to Google and type in Social Security Blue Book of listings, there is a set of listings for children up to 18, and then adults, people over 18. And while the categories are similar, the rules are a little bit different. And, they assume, Social Security may assume that a person who met the listing under 18 doesn't necessarily meet the listing over 18. But it just seems kind of odd that if all the stuff you're talking about, unless there's any evidence of medical improvement, why that would cut them off. But that's, again, why you appeal. Okay, Kathy Clayton had a very favorable CE. Consultative, the doctor suggests a mental evaluation or severe anxiety. Why would the DDS office not request one? I can't answer that. Because they don't have to, unless they feel like there's evidence of an anxiety disorder. They may not feel it's a severe impairment, even if the CE doctor suggested it was.
And if she's not in treatment and you're not on medication, like that's a factor. But DD, like they can suggest that, but then it's better to go to your doctor and get a mental health report completed by your doctor, and don't let them send you. You kind of don't want to go to one of their doctors because they're just going to create adverse evidence. Get the supporting evidence from your treating doctor instead.
I think if that's possible, if it's affordable. Although I will say that, my experience as a consultant of psych evaluations, a lot of times are not harmful. I'd say the physical exams are more likely to be a problem than the psych exams. But you have no control over it. You could get a psych evaluator who is, just basically says you got everything's very mild, there's no real problems, and doesn't help you at all. You're always better off having your own doctor. I would definitely.
And they don't look at your medical records ever, those
Right,
consultative examiners. I mean, they're
They-
missing, I don't know why, but
Yeah,
Yeah.
they won't look at your. I mean, well, the reason why it's real simple is because they don't get paid very much for it. They get paid
right.
$70 or $80 to do an exam. They're not going to pour through 500 pages of records. Okay. Steve says, how long should a CE exam take? His lasted 15 minutes. Didn't look at his paperwork until he pushed the MRI in front of him, did a couple of things and said it was done. Didn't ask or say anything. Yeah, this is not uncommon. And I think what I would do, Steve, is I would write down everything you can remember about that exam.
Yeah.
Write it down. And then, you and your representative put together a form 795 where you basically explain exactly what happened. And if the report comes back against you, file a response to it saying he didn't do anything. This is exactly what happened here, and ask the judge to give that report from the consultative doctor little to no weight. That's how I would handle it. Okay. Okay. Shaker Jones. What kind of information do I have to give for type 1 diabetes in order to win my case? No, I'll give you that one. How do you win a type 1?
They changed the listing, so there isn't a listing for diabetes, and they're looking at the body systems that it's affecting. So do you have neuropathy? Are you on gobs of Neurontin or Lyrica? Do you have retinopathy? Are you having, God forbid all these things are happening, but is your blood sugar not controlled even though you're compliant with medication? Are you on a pump? It's some of these, they just don't have like a one-line answer. It really depends on even how your doctor's documenting the evidence, the medical records. So that's a little tougher because, they got rid of the listing.
Yeah, I would say, keep a diary of blood sugar numbers. And, actually what I found with type 1 diabetics, when the blood sugar drops, that's actually a bigger problem than when it goes high. Because when it drops, you pass out. So if you're having, despite being compliant, despite taking insulin 3 times a day, 4 times a day, wearing a CGM, continuous glucose monitor, you have low blood sugar episodes 3 or 4 times a week. That to me is a really important factor because, that is going to make it a real problem to do anything around hazards, where you're going to be in a customer-facing environment. I just think it's how often. First of all, do you have complications like Noel said, like the vision problems, the retinopathy, the neuropathy, despite Neurontin or whatever else they prescribe, and then is the blood sugar out of control even with insulin pump or taking regular doses of insulin, and do you have episodes of really low blood sugar where you pass out? And that would be that to me would be the things to look at. But I think having a record, and if you have a CGM, it'll do it automatically, showing the spikes of blood sugar, because when it gets really high, you get real jumpy, you can't really focus and concentrate. When it gets low, you pass out, and it can be a real problem. So that's what I think would help.
And I would say the one thing that I find missing in the diabetes cases is when the neuropathy is really bad, but they don't send the person to the neurologist to have the EEG done, because if you can get that objective evidence and it's affecting your hands bilaterally, that really knocks the whole job market out pretty much, if you can prove that. And so that's the line of evidence that I always find is like missing, actually. Get an EEG if you're on Neurontin and you have severe neuropathy.
If you can, absolutely.
Yeah.
EEG is an objective test, and that's very helpful. All right, Julia says, that's what worries me. Now I have a head injury. My biggest complaint is constant dizziness, continuous headache. I live alone. I was 59. This concerns me because I didn't go to treatment. It's a problem if there's no treatment record of it. I mean, again, you can tell a judge about the constant headaches, and quite frankly, there may not be a lot that can be done, but if your family doctor would prescribe prescription medications for for severe headaches, the dizziness, I mean, there's medications that can be done, but it's got to be reported in the medical record. It's not enough for you to go into a hearing and say, I got dizziness and headaches. You got to have it in the medical record. And even for the
Yeah.
doctor, there's nothing we can do for you.
Headaches are the one that people need to keep a log also because they treat it like seizures in regard to the frequency. So they're looking at the frequency and the duration of your headaches. You need to contemporaneously document that. Like just get a monthly calendar and mark it and
Yep.
put the numbers on it and you screenshot that to your rep and you send. It's very hard for a judge to say, no, that's not happening when you're keeping a record of it for the last year,
But
right? We can tell if you used a different pen and you didn't like we can tell.
Yeah.
And the
But-
other thing is that did she say she had a head injury though?
She said she had head injury. Yeah.
Okay, so if it's traumatic brain injury, there was a medical expert that testified in a case one time and said, and this was maybe 8 years ago where they did the CT. I think a CT is the gold standard to get shearing on a head case.
Mhm.
And that expert said, just because you don't see it doesn't mean it's not there. It's that the medical technology has not gotten good enough to see it.
Yep.
And in the last year or two, the technology has gotten sophisticated enough to detect the shearing. So if you go and get that done, they may find that if it didn't happen overnight, I mean, there's no treatment for a TBI. So right? Like you might be able to make a case out of it actually,
Yeah.
in my opinion.
But you got to get the medical treatment. You can't not go to the doctor. And, look, the fact that you live alone, are you having trouble with your daily activities, with paying your bills, with remembering to, pay the light bill, things like that. I think a diary would be helpful here. But yeah, that's going to make it a little more difficult if you're living by yourself and functioning okay, and you're not getting treatment for it. Again, what we said before, if it's not being treated for Social Security purposes, it doesn't exist. So, there may be other things there. I think there are, but that would be what I would say. Okay, Hawk asks this: is it permissible to have and refer to my e-notes during my hearing? Especially, yes, absolutely. I mean, don't read from it. I think I would tell you, don't just read something out of I've had people just read word for word a statement. I don't think judges want to hear that, but you can have copy points to make sure you cover everything. I mean, I do. That's what I have a 3-monitor setup here, and I'm going through, and I got my brief on one panel, like the exhibit file on the other, and I got my notes on the other, and I'm going through to make sure I ask all the questions I want to ask. So absolutely. Okay. Corvettes, 2026 Corvette, we'll just call it that, was approved for SSD on September of 24. When will my CDR come due? I don't see anything award letter. If you don't see anything on there, I mean, it's coded someplace. I would just continue to go to the doctor, continue to get treatment, be compliant with the treatment. You can't control when they send you a CDR, but assuming nothing has gotten better and you're continuing to go to the doctor, you should be fine. I think where they're going after are the younger people 35 and under, and people with mental health conditions. That's where the CDRs are being focused, in my understanding. Okay. Info only. I have a disability hearing from a judge soon. If it would be denied, would I be able to get SSI if my spouse passes away? I have no other form of income. Well, realize the standard for disability and SSI are the same. It's defined as being unable to engage in substantial gainful activity because of a medically documented condition that has lasted or expected to last 12 consecutive months or result in death. So SSI and SSDI are the same definition of disability. So if you're denied by the judge for SSDI, you're not going to qualify for SSI. The difference is SSI is a means-tested program, whereas SSDI is based on earnings paid in, or if you're a widow and somebody else's earnings record. So if you're denied, that's a problem for both SSDI and SSI. Okay, William Adams, good evening. You're my client for over a year. The first time you've seen me live. Well, I'm here every week, and I am live, so I'm not an AI creation, William. That's a good thing. Somebody said I look fuzzy before, so maybe I am. Who knows? I'm not going to tell you if I'm AI though. Okay. Had your CE last week. Well, I wonder how it went. How did it go? And let me see. In fact, I can tell you live and in person if we got the report in. Let's take a look here. There's your file. And let's see if the consultative report has come in yet. I see the reminder.
I would say most of those CE reports they're either very neutral or
Yeah.
not helpful, but the judges also kind of know how the CEs go. I mean, they're not resistant to ignoring that opinion, I find also.
Yeah,
So
William, I'm looking at your file right now, and I don't see the CE report has come in yet. So, yeah, in fact, it has definitely not come in yet. So I do see the appointment reminder. So it looks like you had, the appointment was on July 18th. So it's now the 29th. So it should be here soon. So let's take a look and see what it says, and I'll let you know when I see it. Just if you want to send me an email, just remind me and I'll send you the report when it comes in. But it's not there yet.
sometimes it takes like 30 days, huh? Is about the like marker for everything.
Yeah, it can't take that long.
Mm-hmm.
Is there any indication, Huck asks, that ALJs or staff is using AI to pre-screen briefs? Not much to use AI to decide cases, pre-screen briefs to check on certain case sightings. No, I'm not aware of that. I know that we had Elise Enton on. I had her on maybe a month or so ago, a month and a half ago. She's a former staff attorney, and she said that from what, in her experience and what she's hearing is they're starting to use AI, but the program they've got is very rudimentary. And so it's not really much of anything at this point. So I think it's coming. I mean, Frank Bisignano is a big proponent of computerizing everything. So it's coming, but I don't think it's there yet. So Social Security is very security conscious. So if they're going to use AI, it's going to have to be locked down. They're going to really be, it's going to take.
I think the former commissioner was on some live stream talking about this, maybe with ACRD or whatever their acronyms are, about a month ago. I mean, yeah, they're definitely looking at it.
Okay.
All
right.
Nothing yet, though, really in place.
Yeah, no, there's nothing in play.
No.
Okay. Patrick says, there's one of 25% of standard fee for representation. Yeah, I mean, there's something called a fee agreement, and you can do a fee petition. Fee agreements where Social Security basically says you can do a case on a contingency fee, and 25% is what they allow. So that is pretty standard. A fee petition, an attorney can ask for more if there's more work done, but most people don't want to mess with them because there's such a long, drawn-out process.
Yeah. I just had a conversation with a lawyer today. He's like, I'll just let the fee go. I hate doing them so much.
Yeah. It's a pain. Okay. All right. Hawks asks, should he submit records or not electronically? Sure. No, they're gonna OCR everything. They're gonna optically character read everything. I wouldn't try to play games with Social Security. They're gonna want to search it. I mean, I think that there's going to be more of that coming through, but judges look. I mean, before I used AI, I would use a PDF reader and I would search for words. I would search for MRI. I'd search for EMG or whatever it may be. Very, very helpful to find stuff. So I don't think there's any. And the one thing that Social Security we run into trouble with is people will have a handwritten report. Their adult function report is handwritten. Social Security can't read that. And the judge, judges are busy. They don't have time. I've had judges say to me, if it's handwritten, I'm not going to even read it. So it doesn't benefit you not to have a judge read your records, I think. Based on this live chat, I don't know about you. Okay, well, that's your right to say whatever you want to say. Okay. Hi from Indiana. Tammy, how are you doing? AI helped me with intake forms. They can help me from answer prep. Yeah, it can. I think you just have to use it wisely. That's all. And William said AI is a fancy. No, it's a tool, but it's more than a search engine. It is it's artificial intelligence. It absorbs information and it processes it. It's a lot more than a search engine, I will tell you. No question about it. Okay. Due to my forgetfulness, I have talking points. Yes, you can. You can. I think you just have to make sure you don't read from it, but you want to make sure. Again, I would tell you, you or your representative, if you could do a pre-hearing memo, brief spelling out your argument, that would be a wise thing to do. That way, it's all in front of the judge. But if not, you can certainly have your talking points in a document. No problem there at all. All right, so we are, let's see, we're getting a little light on time here. We got about, let's see, we have been, we've got about maybe 5 or 6 more minutes, so we'll try to run through a couple of these. Can somebody explain to me, I received Social Security $1,000 a month, I was 17-year-old, she was 42 a month, I know people who never worked and that received more. Yeah, I mean, I'm guessing your 17 is getting auxiliary benefits. That seems a little low to me. Why should be getting 42 a month? But there may be some reason for that. But it's hard to tell you an answer. But if you're getting 1,000 and you've got only one auxiliary, I would think it'd be closer to 250 a month. Not sure why it's only 42. Okay. I've been told by people on Social Security that I need to investigate. There must be something wrong with what I'm getting monthly. Other people are receiving 14 and 16. This is the person who's, again, the amount that you get is usually a function of what you've paid in. So, I can't really answer that.
Unless they're not counting some of your earnings, it's not probably going to be wrong because they're plugging it into a system that spits out a number, right?
Yeah.
I mean, really the only place where that would go wrong is if the IRS didn't report everything accurately.
And you know what?
Yeah.
This kind of question, I would contact your U.S. Senator's office, ask them for some help to verify your calculations are correct. Let them work on your behalf.
Mm-hmm.
All right, we have another $9.99 super chat, I think is what it's called. ALJ hearing was on July 13th. The portal updated today, denial for SSI after non-medical review, which means that you probably had assets that took you out of SSI world. SSDI step 4 or 5 for non-medical review in local field office, 33-year-olds, 40 credits, expect denial. I mean, I don't think that the non-medical review, I don't think that means anything. I mean, the SSI part makes sense to me because if you are, if you have assets or earnings or household income that makes you ineligible for SSI, that is a completely different, that's nothing to do with your underlying medical case. The non-medical review basically, do you have any earnings after onset, things like that. I would just wait till you get the decision. Now, anybody who's 33 years old, I Noel said this at the beginning, and I'll reiterate it. Your evidence needs to be like way up here. I mean, this is not. It's hard to win at 33. But
I would say the person could be hopeful though, because if they're doing the non-medical review and they didn't it didn't spit out a denial right away. But with that age, it's cautiously optimistic. You see it in writing. Mm-hmm, mm-hmm.
Okay. All right. We got time for a couple more, then we'll be done. DWS says I'm a 57 above the knee amputee, which I think is a listing. Several of the chronic conditions approved with a 5 to 7 year review. What should I do for doctor's visits? I don't know that there's much you can do. I mean, you're getting medications for thyroid and phantom pain and so forth, but they're not going to expect that your legs are going to grow back. So I think that, if you're listing level because you had a leg amputated, there's probably not a whole lot you need to do other than just, go to the doctor for your regular prescription refills.
Occasionally document that's a bad joke, but sometimes Social Security can be that ridiculous. That's my point on that though.
And if you've tried like a prosthetic and it has not been successful or very painful, make note of that. But although I don't think even a prosthetic would put you in a review category because that's still, you're still listing level.
That's kind of a long time for a review. Isn't CDR 3 years? They really set it out though. And then they don't have time to do that. So they may never review it actually.
A 7 year review, almost probably not going to get reviewed.
Right.
Okay. We're going to do 2 more of these and we'll be done. There's an ALJ, John Sky one, is an ALJ changing the AOD, the onset date, have to be medically credible, not just grid rule turning 50. In theory, yes. I mean, the ALJs are under a lot of pressure to limit their approvals because of the trust fund running out of money. But a decision about whether somebody is at light or sedentary is kind of within the discretion of the judge. So the judge may have found you're limited to light work. You may disagree with them, but at 55, you meet the grid, and the judge may decide that's what I'm going to do. Are there judges who, are trying to limit what they pay out? Yeah. And there are judges who are going to say, well, sedentary is a real push, but I could live with light. That may be what happened there. Okay. This is going to be our last one. Let's see. Ask me or my attorney any questions, just repeat a question with the V, then hung up. Any experience with that? So I think what Vinny is saying is the judge did not ask the attorney any questions, just repeated a few questions with the VE, then hung up. So I guess what he's getting at is we've all had judges that don't say anything. Basically, they start the case, counsel, present your case. I don't know if you ever had anything like that. I've had a few. Those are hard to read. Honestly, they're hard to know what the judge is thinking. I remember there was a judge here in Atlanta when we would do live hearings, and he was known for, you walk in, nice guy, pleasant, and I shouldn't say, he was, didn't say enough to know he's a nice guy, pleasant, just say, we're here for your hearing, counsel, present your case. Never said a word. He approved some, he denied some, very hard to know what he's thinking. So, the questions to the VE a lot of times will give you some idea what the judge is thinking. If he asks one question and it's not work preclusive, that's not a good sign, but you just don't know. So anyway, all right, we are in Bala, who's one of my clients. Good to see you here. Okay, we're going to go ahead and end it. We're at 2 hours now. Noel, I appreciate it. I know we had a little technical glitch at the beginning, but it's been good for the last hour plus. I appreciate that. Any words in closing, words of encouragement, words of wisdom for those folks who are pursuing disability, obviously, other than don't give up and focus on objective evidence and listen to your representative, all those kind of nice things. Anything else comes to mind that you'd like people to know about?
I think we covered a lot.
Yeah.
So yeah, my apologies for the technical. We'll get better at it. But
it happens.
I appreciate you having me on. Thank you so much. It was
are you still doing hearing work, or mostly working with other reps, or what are you doing? Or I know you're doing, tell us a little bit about what you're doing. I know you're doing some of the AI consulting. We'll talk about that another time, but tell me about what you're doing, just if somebody wants to reach out, how they'd find you.
Okay. Yeah. So you can connect with me if you have a Social Security case through Professional Advocates with an S Inc. That's the website address also. My name's Noel Anschutz is the last name. And yeah, I'm still doing hearings. I think it's important for me to stay active, and it's because you need to use your skills, or they kind of get a little rusty maybe, but integrating everything I know and trying to educate people about artificial intelligence and see how we can use it in a responsible manner, and also to keep the person signing the document, the representative who's responsible for making the professional decision, AI needs to help that person do that easier, not for it to be harder for the person. So we're just at a crossroads with AI, and everybody's trying to figure it out. And I think we're all doing our best.
Yeah, no, it's an exciting technology. It's really been very stimulating, for me, just to learn how it works and to use it. But you're right. And I think, the point you make is by, when you continue to be active, it's hard to do this in a vacuum. You have to do it in the context of cases. And I know, like, I've seen some folks out there who are promoting AI services who've never done this, and the things they focus on as being important aren't really that important to me. There are certain things that I know are going to be important to saving me time and increasing my effectiveness. Certain things are just not. And so, you got to, if you know what works and you know what you need, you're going to make better use of the technology. But we are in very exciting times. Just the pace of change is unbelievable. I listen to podcasts about AI, and just some of the stuff that's going on now is just mind-blowing. And it really is very interesting to see. I have no doubt, I'll just give you my prediction. 5 years from now, and hopefully I'll be in a beach with a drink with an umbrella in 5 years, but 5 years from now, I think that there's going to be a lot of AI in Social Security, whether Social Security will be using it to decide what cases to approve, or, it'll just be much more widespread, and there may be, less work for representatives, or not. I mean, maybe Social Security doesn't want things to be handled fast and efficiently. I don't know, but it's going to change things. I think it's already starting to change things. And, if you're a representative listening to this, you got to get on board. And if you're a claimant, be aware that this is something that, is out there, and, you can't ignore it, because it's going to be used, and it's another tool, but I think it's a legitimate tool and can be very, very effective when used properly. So, all right, we're going to wrap it for today. I appreciate, Noel. Thank you for your time very much.
Thank you.
And we'll be talking again about we're going to do a podcast episode about the AI more particularly. But for this evening, I do appreciate you offering your insight, and we'll talk again soon. And everybody else out there, I hope you have a great rest of your week, and we'll see you next Wednesday.
Thank you. Bye-bye.